You know, the vaping industry is a massive, multi-billion-dollar giant. But what happens when its very existence is challenged? Well, that's exactly what was on the line when these companies went head-to-head with the federal government in a legal showdown that landed, you guessed it, right in the lap of the Supreme Court.
So what's this whole fight really about? Well, it boils down to this huge, fundamental question. Are e-cigarettes a life-saving tool for adults who are trying to quit deadly cigarettes, or are they a public health nightmare, hooking a whole new generation on nicotine with all those candy-like flavors? It's a massive dilemma. Okay, so let's dive into the case that blew this whole thing wide open. We're talking about a landmark Supreme Court showdown, FDA versus Wages and White Lion. This was it. You had federal regulators on one side, and on the other, vaping companies were literally fighting for their lives.
So, how did we even get to this point? Well, you got to go back to the 2009 Tobacco Control Act. This law basically said that any new tobacco product, and yep, vapes count, needs a green light from the FDA to be sold. But getting that green light isn't easy. You have to prove your product is appropriate for the protection of the public health. And what does that even mean? Well, it's this tricky balancing act. You have to show that the good your product does, like helping adults quit cigarettes, is greater than the harm it might cause, like, getting kids addicted to nicotine.
All right, so this is where the real fireworks start. The whole thing exploded when the FDA just flat out denied over 1 million applications for flavored vapes, basically telling them to get off the market. Naturally, the companies sued. They said the FDA was being arbitrary and capricious, which is just legal speak for making it up as you go along. Their main argument? That the FDA pulled a total bait and switch on them. They felt like the rules of the game were changed right in the middle of playing. First up, the evidence. The companies were like, hey, the FDA told us we didn't need to do any crazy specific new studies. They said using existing research would be fine. But then, bam, the denial letters hit. And suddenly, the FDA is saying their applications are fatally flawed because they didn't have these huge, expensive, long-term studies like randomized controlled trials for their exact product. You can see why they felt blindsided.
Then there's the issue of comparisons. The companies thought they could just compare their vapes to, say, regular cigarettes to show they were a better option. Makes sense, right? But the FDA came back with a requirement that the companies say came out of nowhere. They had to prove specifically that their flavored vapes were better at getting smokers to quit than tobacco-flavored vapes. That was a whole new bar they suddenly had to clear.
And the third point was about the vape device itself. The FDA had put out guidance that seemed to focus all its attention on those disposable, cartridge-based vapes, the ones that are super popular with teenagers. So companies that made the more complex open-system vapes kind of thought they were in the clear, in a safe harbor. But nope. The FDA ended up bringing the hammer down on pretty much all flavored products, no matter the device. Their reasoning? The flavor is the problem, not the gadget it comes in.
So, you've got these 3 big accusations on the table. The battle lines are drawn. The question is, what did the Supreme Court have to say about all this? How did the justices see it? Let's get into the verdict.
Well, the court pretty much took the company's arguments apart, piece by piece. On the science thing, they said, look, the FDA always said you needed strong proof. On the product comparisons, they decided it was totally predictable that the FDA would ask about flavored versus non-flavored vapes, especially with all the talk about youth addiction. And as for the device type, the court saw it as a totally reasonable move. The FDA got new data showing kids would use any device to get their favorite flavors, so the agency adapted. It wasn't a switcheroo, it was an evolution.
And really, the whole thing gets summed up in this one key phrase from the court's opinion. They said the FDA's tough new requirements were a natural consequence of everything it had said before. So, in the court's eyes, this wasn't some shocking reversal. It was more like the FDA had been leaving a trail of breadcrumbs, and the court basically decided the companies just weren't paying attention.
But hold on, because this is where the story gets really interesting. It looked like a total slam dunk for the FDA, right? Well, not so fast.
Because on one absolutely critical point, the FDA stumbled. In fact, they admitted they made a major error.
So what was this big mistake? Well, it had to do with the marketing plans. The FDA had told companies over and over again that these plans, which detailed exactly how they'd stop kids from buying their products, were a critical piece of the puzzle. So, naturally, these companies poured tons of time and money into getting them right. And then, get this, in the final denial letters, the FDA just admitted it didn't even look at them. Why? They said it was just more efficient to skip them. Can you believe that? Okay, so the FDA messed up. The huge billion-dollar question then becomes, does it actually matter? Is this a deal breaker?
And this is where things get super nerdy, but also super important, because it gets to the heart of how we hold government agencies accountable when they make a mistake. So you've got two big legal ideas crashing into each other here. First, there's something called the remand rule. This is like a bedrock principle of the law. It says that if a government agency gets something wrong, a judge can't just step in and guess what the right outcome should have been. Nope. You have to send the case back, that's what remand means, and make the agency do it over, the right way.
But there's an exception. It's called the harmless error rule. And it's exactly what it sounds like. It says, hey, if the mistake was so small that it clearly didn't change the final decision, then let's not waste everyone's time and money sending it back for a do-over. It was, well, harmless. So you see the dilemma, right? It's a classic legal tug-of-war. On one side, you have the argument for following the process. The FDA called these plans critical, so shouldn't their failure to even read them automatically void the whole decision? But on the other side, you have the argument for efficiency. I mean, would any marketing plan, no matter how brilliant, have been enough to make up for the lack of hard scientific data? Probably not. So if the FDA was going to say no anyway, was any real harm done? So after all that, what did the Supreme Court decide? Which side won this legal tug-of-war? Well, the final verdict was no verdict at all. Seriously, the Supreme Court totally punted. They refused to make the call on whether the FDA's mistake was harmless or not. Instead, they just sent the whole thing back down to the lower court and said, you guys figure it out. So after all this, there's still no final answer, leaving these products, and honestly the entire industry, just twisting in the wind? And that leaves us with a really fundamental question, one that's way bigger than just vaping. Think about it. In a world with so much regulation, where a government agency's decision can literally create or destroy a multi-billion-dollar industry overnight, what's the right balance? When a regulator screws up, how big of a screw-up does it have to be for it to actually matter? It's a tough question with no easy answers.